I know it.
Testing, testing. Okay, so we are on the record in case 9820, the proposed rate increase request by Potomac Electric Power Company. So let me take appearances.
Good morning, Chairman, Commissioners. Kim Curry representing Pepco. I'd also like to enter the appearances of Doug Mikeel, Assistant General Counsel, Taylor Beckham, Assistant General Counsel, as well as Matthew Seegers, Assistant General Counsel, all on behalf of Pepco.
Good morning, Your Honors. I'm Fran G. Francis, appearing on behalf of the Apartment and Office Building Association. I would also like to enter the appearance of Catalin Peter, and I would like to note that a motion for special admissions of out-of-state attorney Fran Francis was filed this morning.
Good morning, Chair Hoover and Commissioners. Michael Sammartino for the Office of People's Counsel. With me today is Brock Miller and Pauline Raisis, and I'd also like to enter the appearance of Jacob Auslander and Ryan Shu.
Good morning, Chair Hoover and Commissioners. Ruthie Herman on behalf of staff. I'd like to also request that the appearances of the following staff attorneys be entered: Lloyd Spivak, Michael Dean, and Harrison Scher. Thank you.
Yes, sir.
Good morning, Your Honor, Commissioners. Garrett Fitzgerald with Montgomery County, and I'd also like to enter the appearances of our attorney Diane Kilcoyne and our State Energy Climate Policy Manager Brian Howard.
Good morning. We petitioned to intervene. This is the Maryland Energy Administration, Michelle Honig on behalf of MEA. Also entering appearances of Steve Tolson, Sandra McLemore, and David Shapiro.
Anybody else? All right. Okay. You want to start with the publications?
Yes, Your Honor. Hopefully this is the easiest thing we have to do this morning. Yesterday, the company filed the certificates of publication. This is pursuant to the suspension order 91903, directing the company to file notice of the pre-hearing conference and publications of general circulation. We filed that under mail log 324427 and would like to enter this into the record.
Okay, so this is Pepco exhibit number 1, I guess?
This will be Pepco exhibit number 1.
So marked and so admitted. So let's see. I guess we should address Ms. Francis's motion. So.
May I speak, Your Honor?
Sure. Mm-hmm.
Good morning, Your Honors. I hadn't planned on addressing AOBA's motion to reject, dismiss, or modify Pepco's application in detail. However, I would like to briefly explain why we filed the motion and how it relates to this pre-hearing conference and the establishment of a procedural schedule, which is why I did not enter into the consensus schedule that I believe was submitted earlier. I will also address other procedural matters such as voluntary data responses and identification of a sponsoring witness for all data responses. By way of background, the Commission in case number 9702, order number 91181, stated, "The form of the next rate case can be any of its choosing, so long as its application is accompanied by the requisite information needed to calculate a historic test year." There seems to be no disagreement about that requirement. However, in response to that direct Commission order, Pepco filed an application comprising both a fully forecasted test year revenue increase of $133 million and a traditional test year compliance filing, which purports to justify an even larger $142 million increase. Neither of those two revenue requirements is premised on a fully historic test year. Pepco witness Lemming's direct testimony, Part 1, indicates that Pepco's traditional test year compliance filing is provided in response to the Commission directive in Order Number 91181. Specifically, witness Lemming states, Order Number 91181, the Commission held that the company's next rate case can be any of its choosing, so long as its application is accompanied by the requisite information needed to calculate a historic test year. To comply with this directive, the company is including information supportive of a traditional test year with this fully forecasted test year, identifying that information with TTYCF throughout the testimonies in the filing. Effectively, Pepco has taken the Commission's directive for the filing the information necessary to calculate a historic test year and submitted a partially projected period that the company references as a traditional test year, supposedly using a test year of 9 months of actual, 3 months of projections for the test period ending 12 months, September 30th, 2025. Historic and traditional are not the same word and do not have the same meaning. We all agree that the Commission ordered Pepco to file the requisite information needed to calculate a historic test year. A historic test year is a discrete period of time with 12 months of actual experience determining costs and revenues. Pepco has conflated this direct Commission requirement into what it calls a traditional rate case. According to Pepco, traditional is a partly historic and partly projected test year with adjustments to reflect anticipated rate effective period changes in costs, as well as the potential for mid-case updates to fully actual data. With Pepco's filing compounding fully forecasted test year considerations and potential mid-case updates for the traditional test year, burdens are placed on AOPA, OPC, and other parties that impede the ability to fully litigate all aspects of the case within the legislatively established timeframes. Pepco's presumption is that the focus of the case will be on its fully forecasted test year, and the traditional test year is simply a compliance exercise. AOBA and potentially other parties may view the traditional test year compliance filing as a serious alternative to Pepco's fully forecasted test year. Both alternatives require serious analysis, and they require close scrutiny. Although this Commission has utilized alternatives to fully historic test periods in the past, in other words, a partially forecasted test year, that is not what this Commission directed in Order Number 91181. Witness Lemming provides an overview of the time periods included in Pepco's fully forecasted test year in his direct testimony, page 6, figure 1. Witness Lemming provides the 2024 historic test year, which is the only information the company has provided that could possibly be in compliance with the Commission's directive to supply the requisite information needed to calculate a historic test year. However, AOBA has identified in the company's application and supporting materials 3 different sets of what are labeled as historic test year costs, and they contain significant differences. As a result, even the actual costs for the historical test year require efforts to identify and verify what the appropriate dollar amounts are. The 2025 bridge year was developed based on fully forecasted data, even though actuals were available for at least 8 to 9 months of 2025 before the company made its filing. Nowhere in Pepco's filing, either in support of its bridge year or its traditional test year filing, do we find actual monthly cost by FERC account for any of the months of 2025. The 2026 forecasted test year is based on a fully forecasted bridge year. AOPA must ask, will the 2026 forecasted test year be updated when the company submits its update to actuals, presumably on December 24th, 2025? That question is unanswered. As we observed in case number 9655 reconciliation filings, significant differences often appear between actuals and even near-term Pepco forecasts. If actual monthly data for 2025 show significant differences for the company's 2025 bridge year forecasts, then the foundation for Pepco's fully forecasted test year must be questioned. Pepco's application forces parties to analyze at least 6 different time periods. Calendar year 2024, the historic test year 12 months ended December 31st, 2024. The bridge year 12 months ended December 31st, 2024. 12,025. Calendar year 2026, the fully forecasted test year, 12 months ended December 31st, 2026. September 30th, 2025, traditional test year compliance filing, the 12 months ended September 30th, 2025, partially forecasted. June 30th, 2025, class cost of service period, 12 months ended June 30th, 2025, which Pepco uses for its traditional test year compliance filing, JCOS and CCOSS, and March 31st, 2025, 12 months ended, which was the rate year on which rates were last set by the Commission in case number 9702, which is necessary to assess the accuracy of past projections and prudence of actual expenditures under the increase in case 9702, the rate effective period. The only fully historic test year documented in Pepco's application is that for the 12 months ended December 31st, 2024. If this commission should elect to set rates on the basis of a fully historic period, the 12 months ended December 31, 2024 is the only period for which fully historic data has been provided, and this is the only time period within this proceeding which could comply with the directives in 91181. Also, it is important to note the company has submitted both a JCOS and a CCOSS for calendar year 2024. Now, getting back to Pepco's representation of its TTYCF. AOBA must stress once again, nowhere in Pepco's filing does the company detail either the actual monthly data or forecast monthly data that the company uses to construct what it calls its traditional test year. Thus, before any party can do any analysis and verification of Pepco's traditional test year compliance filing, the company must come forward with sufficient cost detail to support the 12-month totals it has filed for the traditional test year. In other words, 12 months ended September 30th, 2025. This concern also applies to the foundation of Pepco's 12 months ended June 30th, 25 JCOS and CCOSS. This case is clearly deficient and a significant burden to litigate and should be rejected as a deficient filing. Now to the procedural schedule and voluntary data responses. Pepco has filed an incomplete and procedurally unworkable rate case, and the schedule cannot move forward until the company stops supplementing its application on its own timeline. AOBA's concerns are not hypothetical. They're based on what Pepco has already done since October 14th, and just in the last few days, November 12th, Pepco has uploaded what it calls voluntary data responses, both public and confidential, not in response to discovery, not required by any rule, not disclosed in the application, and voluntary data response number 2 is over 1,200 pages. These voluntary data responses are not helpful extras. They're patches to a filing that was incomplete on day one. Further, these voluntary data responses are not built into the procedural schedule. At this point, we have no idea how many additional voluntary data responses Pepco will provide throughout the course of the proceeding, or when they may be filed. These voluntary data responses are supplements to a deficient application. AOBA requests that the Commission not allow this process to continue. Meanwhile, Pepco's proposed schedule requires staff, OPC, and AOBA to file testimony in January based on critical data that has not yet been provided. Pepco's voluntary data responses result in a denial of the due process rights of the parties. Pepco's voluntary responses are an admission that the application was incomplete. Voluntary responses are de facto corrections or supplements. They supply data that should have been in the application when the company filed it on October 14th. They appear without having been recognized within a procedural schedule, without notice to the parties, and without narrative or explanation. Voluntary responses circumvent discovery rules because voluntary responses are not responses to data requests. By filing these voluntary responses, Pepco avoids discovery deadlines, avoids objections from any party. Without an established schedule, no framework for the timing and scope of an objection can be pursued by any party. Further, this practice enables Pepco to avoid responsibility for explaining inconsistencies. This practice by Pepco evades procedural safeguards this Commission establishes to protect the integrity of the record with the setting of dates and discovery rules. Pepco has argued that voluntary DRs were submitted in case numbers 9655, 9702, and 9618, in all of which AOBA was a participant. Pepco's past practices are not a justification, nor are they precedent to accept this abuse of due process. AOBA has been a consistent advocate for reasonably supported and verifiable information on which the company's application can be analyzed and the parties' positions constructed. In previous cases, AOBA has tried to work with the information provided in the voluntary data responses. However, our experience from those past cases is that voluntary responses are not productive and they serve to impede the parties' due process rights. This practice has never been specifically recognized or adopted by the Commission and provided in a procedural schedule or addressed in discovery rules. AOBA contends that Pepco's past reliance on its own past practices does not authorize Pepco to produce supplemental material on an ad hoc basis. If Pepco believes that additional voluntary information is necessary, it should formally request through motion authorization to file such supplemental information. If there's an error in Pepco's filing, Pepco can file an errata to remedy that error and submit a red line version indicating the corrections and what necessitated those corrections. Amending the evidentiary record is distinct from the applicant augmenting the record at will. AOBA's position is that if voluntary responses are allowed, the legislatively determined time frame cannot begin until the company's application is complete, demonstrated to be in the public interest, and not until all voluntary responses have been submitted. Otherwise, parties do not know what record they're litigating. Proposed filing dates become arbitrary, with Pepco having unilateral control of the timing, material, and scope of the record. Now to specifically address the procedural schedule. Pepco's representation that it will subsequently update its traditional test year compliance filing to reflect fully historic data on December 24th, 2025 is procedurally problematic and must not be permitted. Pepco's proposed date of December 24th, 2025 for its update to actuals is untenable, as it does not provide the time necessary for discovery, to review responses and prepare direct testimony regarding the information that would be contained in such an update to 25% of the company's request. Any data request submitted after January 1st would leave less than 3 weeks to evaluate the response, analyze the data, seek follow-up information, and complete direct testimony. Pepco, on the other hand, gives itself 70 days to provide updated information, while parties get less than half that time to analyze the update and submit testimony. It's also important to note that Pepco witness Schaefer has also stated the company, quote, intends to update the revenue requirement included in the CCOSS TTYCF to the 12-month period ending September 30th, 2025, during the proceeding. When during the proceeding is not specified by witness Schaefer. Finally, Pepco's application is not complete, cannot support a tenable schedule determination, as it depends on data that Pepco has not provided. The difficulty of updates to supposed actuals for the 12 months ended September 30th, 2025 is compounded by the fact that we can also expect updates to the CCOSS and updates to the projected capital structure as well as the cost of capital. So now I'd like to mention one additional procedural matter. In past proceedings, Pepco's responses to data requests have frequently not been sought by a witness. Many of the company's responses have been sponsored by the company. This practice has made it difficult to submit follow-up data requests and also made it difficult to prepare responsive testimony and to allow parties to develop cross-examination. Parties should not have to ask the same question of multiple witnesses to determine which witness, if any, assumes responsibility for the information provided. No other party engages in such a practice, and Pepco should not be allowed to continue it. In conclusion, Commissioners, this case should not go forward as presented on Pepco's terms. Pepco chose the filing date. Pepco chose the test year, 12 months ended September 30th, 2025. Pepco chose to omit actual data. Pepco chose to upload piecemeal corrections, additions, labeled as voluntary. And now the Commission is asked to lock in a procedural schedule built on forecast, contradictions, and documents that do not yet exist. AOPA is requesting, in the interest of its members, appropriate due process safeguards from having parties address basically a shifting and unknown target within a statutory time frame that doesn't provide enough time for fully addressing and responding to Pepco's application as filed. If Pepco is permitted to pursue the application, safeguards need to be implemented to protect Maryland ratepayers, such as not allow Pepco to continually supplement its application throughout the proceeding by the filing of voluntary data responses. Specifically, AOBA urges this Commission to dismiss or reject Pepco's application on the basis of non-compliance with Order Number 91181 and the Commission's statutory authority to reject or modify a proposed MYP if it finds the application is not consistent with the public good and not in the public interest. Alternatively, AOPA would encourage the Commission to modify Pepco's application to exclude the traditional test year compliance filing and all forecasted costs for future periods and determine Pepco's revenue requirement based on calendar year 2024 costs and revenues under a 7-month litigation schedule, subject to Pepco's reconciliation of the cost differences for calendar year 2024 that AOBA discussed in its motion at page 18. If Pepco believes that further modifications to its rate-making adjustments for calendar year 2024 are needed, then the 7-month schedule should not commence until Pepco has filed supplemental testimony and exhibits to support such modified rate-making adjustments and removed inconsistencies in its reporting of actual calendar year 2024 costs. Additionally, Pepco may file a new rate application based on a fully historic period as required by Order Number 91181 with adjustments for known and measurable changes under a 7-month schedule and implement a potential rate increase at about the same time as it would under the current 10-month litigation requirement. Your Honors, thank you for this opportunity.
Okay, any questions for AOBA?
Mr. Chair, can I ask questions after we hear from all of the attorneys?
So does anybody have any questions for AOBA at this point, just based on what they said? All right. So now I know OPC filed something and said you were going to file an official response to AOBA's motion later this week, but why don't you go ahead and opine to the extent you can on AOBA's motion and other procedural matters related to the schedule.
Thank you, Your Honor. So we share many of AOBA's concerns with the rate application that Pepco has filed. I know my experience might be more limited than some of my colleagues at the table here, but the historic test year filing is unlike any historic test year I've ever seen. I think there's rate-making adjustments to the test year that extend the projections farther into the future than the actual forecasted, fully forecasted test year the company filed. If our agreement in principle to the procedural dates that were proposed, is, if we had to litigate under, the framework that the company's filed, we still share concerns with the update to actuals, but we can, given the statutory time frame for this commission to make a decision on the application, we can work within the framework that the company filed, but our preference would be for this commission to consider whether Pepco's actually complied with its directive in 91181. And I'm happy to talk about the procedural rules that we proposed, but I think that this preliminary matter might
Yeah, no, I understand.
might take
So,
precedent.
and when you say that, you're talking more about the filing you made related to data request and
Yeah,
response.
that's
okay.
correct,
Yeah,
Governor.
let's hold that for right now.
Yeah.
So, staff, same situation. An opinion on AOBA's motion? Go ahead.
Thank you, Chair Hoover. Staff would respectfully request that we be allowed to file our response by Friday.
Okay.
Thank you.
Alrighty. Any other parties in the case who have a strong view on this before I turn to Pepco? Seeing none, so go right ahead.
All right, thank you, Chairman. AOBA makes an extraordinary request here, and that is to dismiss our rate application. And I'm going to go into the reasons why that is not a legally supported request. How about now? Oh, there we go.
Yeah.
So AOPA makes an extraordinary request to dismiss our rate application. And I'm going to go into the details as to why that request is unsupported by law. But before I do that, AOPA discussed some challenges that they have to our testimony, to our filing, AOBA has a right as an intervener to have challenges and oppose our testimony, but their remedy when they do disagree with our rate application is not to seek dismissal. Their remedy is to file testimony. Their remedy is to ask data request if they have clarifications that they need to make. That is what we propose to have this case going forward. They will have their ability to make those points, make those challenges, but doing it at a pre-hearing conference is not the forum. The proper forum is for them to file that in testimony. Now, let's talk about the request itself, which is to dismiss this case on the basis of what AOBA Council just talked about. And I'm also going to talk about the historic test year. I'll talk about that at the end. First, I want to talk about procedurally what the Commission is required to do upon the filing of a rate case. The Commission cannot grant AOBA's request for a dismissal, and that's because the Commission is required to convene a proceeding and have a hearing under the PUA when a company files a rate application. That is the statutory duty. When the Commission receives a rate case, they have to convene the proceeding and determine whether or not the rates are just and reasonable. There's not a provision in the PUA that says the Commission can reject it if it's poorly timed. There's not a provision in the PUA that says the Commission can reject it if it's too complex. That does not exist, nor did AOBA cite to anything in the PUA that allows the Commission to reject on the basis of the timing not being right. And the Commission recognized the statutory duty when you issued your suspension order, Order 91903, where you set or convene the proceeding. So that is what the Commission's requirement is by the PUA once you receive a rate application. I'd like to address AOBA's comments about the Commission has the authority to reject the rate application outright because it's not in the public interest. We disagree that the Commission has that authority. And the reason why we disagree with that point is every decision the Commission makes, you have to ask yourself whether or not it could survive judicial scrutiny. When I looked at the requirements for judicial review in the PUA, it says that a decision of the Commission will be upheld unless unsupported by evidence in the record as a whole. To date, we don't have evidence in the record as a whole for the Commission to make a decision whether or not to accept or reject this application. Right now, all we have are filings and testimony of counsel, and at the time of filing, counsel was not licensed in the state of Maryland and had not filed her admission for or a request for special admission, which is required by COMAR. So all the Commission had in the record was testimony of counsel, and the PUA provides guidance on what is evidence, what is the record. The evidence is testimony and exhibits. AOBA's motion is not evidence. AOBA counsel's testimony and statements here today are not evidence that could form the basis for the Commission to make a decision whether or not this case is in the public interest. AOBA's motion also impairs our due process rights. As I mentioned at the outset, AOBA has the right to challenge our testimony. In the motion for dismissal, AOBA directly challenges the testimony of witnesses Corsi, witness Lemming, witness Schaefer. This is improper because it denies us our ability to challenge those assertions. We have the right to cross-examine, we have the right to ask for discovery requests. If that's just in a motion to dismiss that is filed with the Commission, that impairs our rights. And under PUA 3107, we have the right to present evidence and we have the right to cross-examine, and we cannot do that on the basis of the assertions made in AOBA's motion. The fourth point, AOBA's argument that the absence of orders and the lessons learned and reconciliation process prevents this case from going forward. That was mentioned in AOPA's record. Again, looking at the PUA, going back to the statutory requirements of the commission to convene a proceeding to determine whether or not a rate is just and reasonable. There's not a provision, like I mentioned, for it, to deny it based on it being poorly timed, nor did I see a provision that says the commission can deny the case because of a pending order. Not only that, AOPA's request goes against commission statements that's made in other contexts where it has said that the timing of the filing of a rate case, MYP, traditional, is left up to the utility. Those were the commission's words. So that is a decision that that rests with us. And AOPA's motion and the positions it's taking, particularly that we have to wait till particular orders are issued, goes against that principle of us being in control and having the discretion of when we file. Now to talk about the historic test year. There are two responses to that. So AOPA states that their interpretation of the Commission's directive in Order 91181 was to file a fully historic test year. The first thing I'd like to say about that argument is it will be moot in about 35 days. In the procedural schedule, and we filed it this morning, there is a line item for update to actuals. We, as the parties, dispute what that date should be. But there is a line item and a provision to update to actuals. What we have proposed is December 24th. So in roughly 35 days from now, there will be a fully historic test year. Everything will be updated to actuals at that point. So it will be moot at that point. But talking about the interpretation of what a historic test year is, we disagree with that foundational principle. This is because the Commission has recognized that historic test year cases include a partially forecasted period. It's been something that's been accepted by the Commission. I cite to statements that the Commission has made before that this is something that has been accepted by the Commission before. Not only that, in Pepco's 2013 rate case, the Commission issued an order saying that at minimum, Pepco, when it files a rate case, should do 8 months of actuals and 4 months of, and could do up to 4 months of projections. The Commission has said, has blessed and directed us to file, or gives us the ability to file a partially forecasted rate case. In this case, we even went more conservatively. We went 9 plus 3, even though the Commission in their order in case 99311 permitted us to use 4 years of projected data. I'm going to talk now about the voluntary DRs. AOPA Council did speak a lot about that. I want to give the Commission some context about what a voluntary DR is and what it entails. First, I'd like to talk about the history. This is something that we have done, Pepco has done, and DPL has done in the past 3 rate cases. For the purposes of Pepco, we submitted voluntary DRs in case numbers 9655 and 9702. Those were our first and second MYPs, and we also did it in the Delmarva Power MYP. I will note that AOPA did not object in those Pepco cases when we had submitted these before, but let me give you some examples of what voluntary DRs include. It includes the credit ratings for the last 10 years, and we provide this unprompted by the parties. It's something that we have done as a matter of practice, really to help the parties, to give them some additional information. Credit ratings for the last 10 years. We give them security analyst report, Exelon presentations from earnings calls, Pepco Holdings equity contributions to Pepco. We give them the most recent JD Power residential electric study. We give them the most recent customer satisfaction survey. We provide information on Exelon employee benefits. So these are really kind of some general information in support of our rate case. Like we said, we've done this as a means to help the parties to get out in front of some questions they may ask. And it really is there not to act as a burden, but to give the parties this information so that they don't have to write up their own data requests to ask for them. We've used the same questions over those past few years, so AOBA cannot claim surprise about the types of questions and the types of information we're going to be providing. Again, this is something that we've done for the past, PHI has done for the past 3 rate cases. This is going to be the 4th. So this should not be a surprise to the parties, and certainly not a basis. Providing this information that we've consistently done over the past 3 rate cases certainly should not be a reason to dismiss a rate case. One other, just kind of two other points. Getting back to how extraordinary this relief is, COMAR 200701. This is practice, and it's in the Commission's practice and procedures section. What that provision says is that when an application is filed with the Commission, if it does not conform with statutes and regulations, what the Commission does at that point, is to advise the party, the applicant, of the deficiency and give them the opportunity to correct it. I mention that because the relief there, even if it's found not to be in conformance with statutes and regulations, is not to throw the filing out. That's not what the practice and procedures provisions say. It says that the applicant is given the chance to cure. So I just point that one out just to show you that what AOBA is requesting is just not supported by law. But I say that to say they have not alleged, from what I could see in their filing, a violation of a statute and regulation. I understand there's some differences in interpretation of the Commission order, but I did not see where they have alleged a violation of a statute or regulation. So there's just not support for to give AOBA the relief that they are requesting. AOBA did also mention abuse of due process. They mentioned that in the context of the voluntary DRs that we're providing. I do want to talk about that. In case number 9702, AOBA filed to postpone this case. They've done it here again in this proceeding. For the Pepco DC case, AOBA filed 2 motions to dismiss there. My concern is that AOBA is, that this is a pattern of AOBA to make filings that impairs our rights to file a rate case. In 9702, when AOBA asked, and other parties did as well, for us to delay our case, in that instance, we were, good citizens, and we did. We delayed our case by 3 months. But as I mentioned in our filing and our response to AOBA, that cannot be a sustainable means to handle this, to ask us to actively deny our rights to file a rate case. Here, we ask that the Commission perform its statutory duties, convene the proceeding, have a hearing, give the interveners the opportunity to file testimony, ask us discovery requests, and have parties have their due process as well as us. We have not, I don't recall if the parties talked about the updates to actuals. Oh yes, AOBA counsel did speak to that. Update to actuals is a line item in our procedural schedule. You'll see that I have marked as disputed. We have proposed to update our actuals on December 24th. Other parties wanted sooner. I looked back at our last 6 rate cases, and in 5 of those 6, there was 2 months or greater for as a period to update to actuals. What AOPA and OPC are requesting is to do it, I think, maybe in 5 weeks, maybe 4 or 5 weeks. That is so out of line with other instances historically where the company has filed update to actuals. It is a very, very small time period, and it is not consistent at all with prior procedural schedules that this commission has approved. So we ask that the update to actuals be set as December 24th. Also, it's the period for us to, after the close of a quarter, give us that opportunity to validate the data and flow all those updates in through our revenue requirement testimony. So there is a process to doing that. 5 weeks just is not a reasonable time period, and like I mentioned, is not consistent with prior cases. I believe that, one final point, other parties have asked for time to respond to AOPA's motion. I do not see why a week is needed to respond to that. We filed ours in, I think, a little bit over 2 business days. It does delay the process of approving a procedural schedule. It kind of puts things in limbo. So it's not clear to me why an additional week and a half is needed to respond to AOPA, or what the parties could possibly add. Either they agree with AOPA's motion or they do not. So something like that could be, should be able to be resolved sooner than a week and a half that the parties are asking to respond. I believe that is the close. I understand OPC had filed some additional discovery rules. I don't know if Council for AOPA has talked about those just yet, but we did have some objections to
Actually,
to that.
let's defer that for
Okay.
time being. So, okay. So you're finished with.
I am.
Okay. So questions for the Commissioner Sussman.
So, Ms. Curry, so I'm looking at our order 91181, page 30. So this is the last sentence in that last full paragraph. The form of the company's next rate case can be any of its choosing, so long as its application is accompanied by the requisite information needed to calculate historic test year. What was the company's understanding of our requirement that you also include information to be able to calculate a historical test year?
So the definition of historic test year, as we see it, is it can include partially forecasted data. So our interpretation is, and again, this is looking at commission precedent, which we cited to in our opposition, is that the commission, I think it said something like the commission has indicated a willingness to accept partially forecasted data in the context of a historic test year. So our interpretation is exactly that. A historic test year can include partially forecasted data, and the commission has previously accepted that in traditional cases.
Okay, so was it your sense that what we were looking at was the ability to impose a finding based on a traditional test year model as opposed to a multi-year model?
That's the reading of a historic test year would be akin to traditional rate making.
Okay.
And those terms are sometimes used interchangeably in HTY, a historic test year and a traditional rate case.
Okay, and so in previous cases before the MYP approach, when you first filed your case, would you have ever filed 12 months of historic test year data?
In which type of cases are you
So this
referring
is
to,
this is
Commissioner?
in your previous rate cases before the MYP construct. What would you have, when you first filed the case with the commission, what would you have included in terms of data?
What the commission required us in case 9311, which is at least 8 months of actuals and 4 months of projected.
Right, not what we required, but when you first submitted your application for rate increase, what did you include in that application
Prior to,
prior to the MYP?
as I mentioned, we could file anything up until 8 months, and hopefully I'm not misunderstanding your question, but we could file 8 months of
Right,
actuals.
the very first day that you filed your application with the commission for a rate increase, in that application, what did you rely on in terms of support? Was it a 12-month historic test year, or was it the 8 months of historic and 4 months of projected?
It would be the filing would be 8 months of actuals and up to 4 months of partially forecasted data. This information we can look at historically. So your question, I think, can be answered by looking in the looking at our prior
I
rate
guess
case.
what I'm asking is in terms of what you filed in this proceeding, was this any different than what you would have filed if you were filing a traditional test year case and not include either a fully forecasted or an MYP?
And would have not included in prior rate cases. We have included forecasted data.
Okay, so in previous cases, you said you looked at 5 or 6 previous cases. In any of those cases, did you ever include a full 12 months of historic data when you first filed the case?
I would say no, and the reason I would say that is I had looked at the procedural schedule for all of those 6 cases, and they all had a line item for update to actual. So just based on that, I would assume that meant that we filed some partially forecasted component of it.
Okay, so if we were to require 12 months in this case, that would be different than anything we've ever required in any previous rate case.
From the outset, yes. The way I take your question is the commission making a different request today by, if you were to adopt the interpretation that 12 months from the date of filing is necessary?
Right.
Hopefully I'm understanding your question
Yes.
correctly. As I mentioned, my history, it has always included, I shouldn't say always, but in the rate cases that I researched, there was some partially forecasted component to it that we later updated, which would lead me to believe from the beginning we did not file a fully historic one. But may I say, I don't think we need to even kind of get to this question. We will be updating them to actuals December 24th.
Yes, no, I understand that, but there is a time lag, and so any sort of lost time is to the detriment of the rest of the stakeholders. So I just want to sort of understand whether this what you're including now represents a diversion from what we had done in the past, which it doesn't sound like it reflects that. So it sounds like AOBA is asking for something that's different than something that you've done in the past in terms of the 12 months of historic data.
And that would be correct. And I do disagree with AOBA's assertion that they're somehow prejudiced by this because, again, this is something that we have always done. Again, don't want to use the word always, in my research that we have done in recent history. So there can't be a claim of prejudice when the AOBA has kind of lived with this for the past, 6 rate cases. So I disagree with that assertion that there's somehow that AOBA is somehow disadvantaged by an update to actuals.
Okay. The data request recommendation that AOBA has made about having witnesses beyond the data response. I could tell you from this commissioner's perspective that would be incredibly helpful because I've seen, I've only been on the commission for a little more than 2 years, but in that time, I've seen, sort of confusion and questioning because someone didn't know who was responding, and so would this be a burden on the company if you could include the witness that is responsible for the response?
It would not be a burden, and I had meant to include that in my outbound. That is something we can do.
Okay.
We will identify a sponsor
Okay.
as a witness and not the company.
And Mr. Chairman, can I ask Ms. Francis? Okay, so you heard what Ms. Curry said in terms of what has been done for traditional rate cases in the past, and so can you? So for historic test year, do you disagree with her that in the past a full 12-month historic test year was required and the company submitted that in their filing?
It is a bit embarrassing for me, who has sat in front of this commission for 40 years, that I can't answer that question off the top of my head without doing some research and being confused. But the only way that I can answer that is we are in a completely different paradigm than we were before. This new paradigm of multi-year rate cases is very, very different from what happened prior to that time, I guess the past 5 years. So I can't tell you now because I have not researched the cases. Have they ever provided updates to actuals or not provided updates to actuals? But what I can say is Ms. Curry spent some time saying that there was no authority for the commission to reject or modify what the company have filed. We relied on the specific words of the commission in 2 orders.
Well, yeah, but if I can, I think that my questioning to her is actually an important one because you're actually asking us to then deviate from precedent. If we've never done this before, that gives me some pause about whether I'm looking at this language, and of course we wrote it. But if I were not here looking at this language, I would think that it means that we are asking for the kind of information that we would need if we were not doing either a fully forecasted test year or multi-year. But what you're asking is for now something completely different.
I don't view it as we're asking for something completely different. I looked at the literal words of the commission, based on historic test year. I looked at it in the time frame of their filing of multi-year rate plans because things were less of a problem prior to multi-year rate plans when we weren't actually litigating 2 separate rate cases within a short time frame schedule. Then we had a 7-month schedule, and we were litigating, 1 request for a rate increase. So what we were able to accomplish in that type of a proceeding really isn't relevant to what Pepco is doing now with the multi-year rate plans, where we're trying to litigate different time periods. And in this case, it is particularly different because we're looking at 2 completely different things.
Okay, but you're asking, so you're asking us to actually change the way that we do things, and I'm not faulting you for that, but I don't think that you can then argue that represents a deficiency on the part of the company. I mean, we could actually in an order say, well, we're changing from 8 months of historic and 4 months of actual to 12 months of historic. But since we've never asked them to do that in the past, that can't be the basis for us to then find that their filing is patently deficient. I mean, that's a pretty extreme remedy. And so, I mean, I don't think that the company would challenge that they have the burden. And if they haven't met their burden, then we'll reject their filing. But it'll be after reviewing all of the information and all of the filings. But you are asking us to change precedent. So I don't think that we can expect the company to have anticipated that we would change precedent and then do something different. That's a pretty heavy lift.
I understand where you're coming from, and I understand your questions about prior to the MYPs. I look at, since the MYP periods, we are in a different paradigm, and since I guess 2020, we are looking at different cases. I view this case as very different from the other two MYPs that we litigated, because the commission had very specific requirements as a result of case number 9702, what it wanted to see so that it could calculate a revenue requirement based on a historic test year. So I read the commission's request very literally, and that would mean the company would need to file 12 months of actual data, that this commission could take that actual data and compute a historic revenue requirement, whether you wanted to compare that to their MYP
Yeah, I have to say
filing or not.
well, I think you have to read the entire order. But I also think that it's a little bit of a stretch to then take this and especially since historic test year has been a defined term before the commission, now you're asking us to redefine it. And that may actually be an appropriate thing to do, but that doesn't justify then finding that the company was wholly and patently deficient in what they're providing to us. That could just be some of the argument that you make during the course of the case. I mean, it's an extreme remedy to throw out the application. And Mr. Chairman, I don't think that we're at a place where we can do that. I think all of the arguments that you're making are perfectly valid and can be made in the course of the proceeding, and we can then find, if it's appropriate, that 12 months of historic data should be the way that we look at things, and that the next time they file an application, they should do that. But we've never signaled that, and so I think it would be unfair to the company to place that kind of burden on them. They can't possibly know that we could think about changing the way that we do things at some point in the future.
That is why AOPA's motion said reject or modify the company's filing. And as I said, looking at the commission's words very literally, where the commission said in two orders, I have the order number.
But we're not in a position to be able to say that 12 months is appropriate. I don't think that we can rule on that. I mean, I think we can rule on something like this after we've gone through a rate case and we've heard all the testimony. I can't tell you now that 12 months was the kind of data that we expected. I don't think we're in a place where we can make that kind of ruling now. We don't have that kind of testimony before us.
What we can say is at this moment, the commission cannot make a determination on what would be a revenue requirement for a increase based on a historic test year, because that information has not been filed. That, at this point,
That's your interpretation of, I mean, I can tell you that based on how we've treated historic test year. In the past, we have everything we need before us. Whether that the information that's there supports their case, that's a different story. You're asking us to change how we look at historic test year. And we might do that, but you're asking us to change precedent, and you're asking us to do that today.
No, I wasn't asking you to do it today. I thought you would need more time.
No, but you understand what today
no,
you
I
are
understand
asking.
what
You're asking us to change precedent based on almost nothing in the record at this point because it's so early in the process.
I'm asking you to recognize that at this moment, there is 1/4 of...
A little closer to the microphone.
Oh, I'm sorry. Okay. Is that better?
Yes.
Okay. I am asking the commission to recognize that at this moment, at least 25% of the company's case has not yet been filed. And so we don't know what they will file and what you will be able to
Okay, I'm
determine.
confused about that. If we think that historic test year is based on 8 months of historic and 4 months of forecasted, then what part of the 25% has not been filed?
Well, when the commission made their determinations in the past, they had at that time the actual data they need because it had been updated. So
Wait,
what I'm
when
saying
the
is,
commission made what?
in the past, when the commissions made determinations,
No, I'm talking about when the company made its filing
correct,
in each of those proceedings.
correct.
And maybe, Ms. Curry, if you could just confirm that that's the case, in each of those filings, when the applications were first made, they included at least 8 months, and maybe more, but it would, at a minimum, 8 months of historic and 4 months of forecasted.
Correct.
And the commission never found, and you never argued, that those filings were deficient. But you're arguing that now, and I'm trying to understand, you're saying 25% was not included. And Ms. Curry said that they included 9 months of historic, and 3 months of forecasted. So I'm trying to understand what the 25% is missing.
What you and I are going around about is when they passed cases, now they've been decided. And as Ms. Curry said, there were updates to actuals made during the course of the proceedings. So
Right.
the commission at that point had the updates to actuals and made their determination based on what they had at the end of the case.
Yeah, but we're not at the end, so the
Correct.
only thing that we can look at is how the commission has treated applications in each of those proceedings. And the commission and they were all historic test years, and the commission never found that they were deficient. And they had, at 8 months of historic, 4 months of forecasted. Today we have 9 months of historic and 3 months of forecasted, and then they're going to do an update, but I don't think that has anything to do with the application itself and whether the application is deficient. So if you can find precedent, because you said you haven't sort of looked, if you can find precedent for when we've rejected an application that included, that didn't include 12 months of historic test year data, that I'd like to see. Otherwise, I don't understand what the argument is.
The argument is, in the past cases, before the MYP, they were much less, there were much less problems with those cases. They were more straightforward. You could look at what you had in front of you, and you could litigate based on Pepco's 4 months and 8 months, 9 months and 3 months, whatever they came up with. It was possible to litigate those cases, and we did not ask for those cases to be rejected. This case, we asked for it to be rejected because we do not believe that a traditional rate case, what Pepco has done in the past, is the same thing as filing 12 months of historic data.
That's fine. You're asking us to change precedent, and you can do that, and that can be in your briefs after we've heard witnesses and testimony. If you want to change commission precedent at that point in briefs, we'd certainly be happy to hear that. I don't think that today is an appropriate venue for changing commission precedent in terms of how we look at historic test year. And that is a completely, unless you can find a precedent for us doing that in the past, I don't think that that's a basis for finding that their application was based on commission precedent. I don't think we can find the application deficient if they relied on commission precedent. So, and Mr. Chair, that's all I have.
Mr. Linton.
Thank you, Mr. Chairman. Good morning. It's weird. I get a whole menu of options here. So let me start with Pepco. This whole line of MYP pilot cases, the companies regularly acknowledged that the commission has the authority to take the MYP filing and convert it to historic test year if it determined that that was in the public interest. Is that still the company's understanding?
This case is not an MYP. It is a fully forecasted test year, so it is not an MYP.
Okay. So you're not expecting anything along the lines of a conversion like that?
Of converting it. I do not know if there is orders on that point as it relates to FFTY. I suspect not. So I cannot point to any precedent that I know of that discusses if an FFTY should be converted.
Okay. All right. So obviously AOBA is suggesting that this entire case get rejected. And you've suggested that there be a chance to cure. And it sounds like a lot of this is tied to their need for additional information. So I know you've been producing some information through what you've described as voluntary discovery. Do you have more voluntary discovery to provide, or is that, or are you finished with that at this point?
In the past, we have done 2 rounds of voluntary discovery, and we've done 2 rounds in this case as well. So I would suspect not, just because typically we've done voluntary DR1 and voluntary DR2, and we've produced both of those. So I will say at this time, I'm not aware of any additional discovery. I will also say I do not see any deficiencies from a statutory or regulatory standpoint. I only mention that precedent just to show how extraordinary the request of AOBA was. I did not see that AOBA was alleging a violation of a statute or regulation. There's the question about what the commission's order says and the interpretation of the order. So that wasn't suggesting that we get time to cure. Personally, the company's filing was complete, and there is nothing to cure. I was only adding or referencing that regulation just to show, how different AOBA's request is.
Okay. Are you providing information in the discovery process now that should have been included in your original filing?
No. Now we are actively responding to data requests being submitted by parties that relate to testimony in our rate application.
So the voluntary discovery responses weren't information that should have been in the initial filing?
No. As I mentioned, we do that really to assist the parties. So that they don't necessarily have to go out and look for our credit ratings for the last 10 years. That's just something we could provide. As I mentioned, like the customer sat surveys. These aren't things that necessarily link directly to testimony, but just to prevent the parties from having to write out DRs on these topics, we just offer them. So I do not see it as a deficiency. It's more to provide the parties with tools as they review our rate application.
Okay. So I know that a couple parties have agreed to the proposed procedural schedule. Both OPC and staff have specifically. And the update to actuals date that's been proposed, I believe you said it was December 24th?
That is correct.
Okay. I'm curious, was that date and information provided to the other parties as well? Is that
We discussed that date in the context of our negotiations over the procedural schedule. So that is when we had told the parties about about that date. We also had some pre-filing meetings with the parties where we had circulated a draft procedural schedule, and we had a line item for update to actuals there. So prior to the filing, we gave that information to the parties as well.
And, Your Honor, if I could clarify, OPC has not agreed to the update to actuals date.
right? Right, but the rest of the procedure schedule you're good with.
Subject to our reservation of our right to propose modifications based on what date the commission decides will be the update to actuals date.
Okay. All right. Well, I guess along those lines, thank you, Ms. Curry, then, since you've joined. What is your proposed date for the update to actuals?
OPC's, I think the initial position we shared with the parties was November 26th. And I think we were willing to live with December 1st. Quite frankly, we're open to hearing other alternatives. But the December 24th date is quite unfair, given the timing and the fact our witnesses have families and it's Christmas Eve. And we're already at in order to get a jump start on discovery, we'd have to start reviewing and preparing DRs on Christmas Day through the New Year holiday. And we don't think that's a reasonable request of the parties.
So they're not interested in that Christmas gift. So is there some flexibility in the company's part to move further?
There are certain steps we have to take to validate data, to, as I mentioned, update revenue requirement, update, update schedules. So we do need that time. In fact, we usually, something like this after a quarter close, and what we're updating is
So
from
actually, before we
September.
get too far down this road, why don't we hold off on that issue until we've sort of let people ask questions about this broader issue of the motion to dismiss? Because, it may be that the next thing we take up is the schedule itself, and then we can talk about that date. So,
Okay. Well, actually, Commissioner Sushman asked most of my other questions about to AOBA, so
okay, all right.
thank you.
Commissioner Barbe.
Trying to think of what questions I have that are unasked. So, when it comes to Ms. Curry, when it comes to partially forecasted actuals, I presume what's going to happen is you're going to give us the actuals and then explain what the update, what the forecast is based on the actuals. So I do get to see the actuals.
You do get to see the actuals. The actual form, I'm not sure of. Again, this is something we could look in the record to see what we've done in past cases, and I suspect it would be the same as what we've done in past cases. But the items that you list not having, what we've done in the past in front of me, it's I can't I'm not aware of what's exactly included in the update to actuals.
So let me ask the question a different way. Well, no, I asked you if I'd see the actuals.
You will see the actuals, yes.
So therefore, I will know what the difference between the forecast and the actual would be.
Yes, you would have on the record and I apologize if that was your original question, you would have what our forecast is, and then, because we filed that as part of our rate application, and then you would have the actuals.
And I presume that you would include in your forecast the rationale for the forecast.
Let's see, that I am unsure if we've done that in the past, explain the
What will
differences.
you do in the future?
Well, we want to be consistent with what has been accepted by the commission in the past, what we've normally done, what we've historically done. So I'm afraid I do not know the answer to that question. If we include an explanation for all the different variances, we do want to remain consistent with how we've handled this in the past.
Well, okay, I understand that, but as a commissioner, if you have a line item where the actual is $1 million and the forecasted adjustment brings it up to $1.2 million, I would find it very, very helpful to understand why you did that, what the rationale was, and how the calculation was accomplished. I'm just telling you what I want.
Yeah, and thank you, for that. One question I would ask is that information relevant when you do have the actuals?
Yeah, it would be, and I'll tell you why. Because if you make a decision to deviate from actuals and the deviation is greater than the rate of inflation, I'd like to know why.
We're not, deviate from actuals, and.
Well, if you have an actual number and then you have a forecasted actual number that is substantially higher, I'm not saying that's a bad thing or an inappropriate thing. I'm just saying I want to know why.
Again, I would have to take a look and see what we've done in the past. I mean, as I mentioned, we want to remain as consistent with what we've done in the past, how the commission has historically handled historic test year rate cases. Our goal is to keep that continuity. And I'm simply not sure if we provided explanations for each one of those deviations.
Okay, well, I mean, I think it's important for us. Certainly, it's important for me. I don't want to prejudge how I feel about your, method of presenting actuals. I don't want to prejudge that. But what I do want is a comfort level of knowing that your projection is a reasonable one, because I'm going to be held to account for, voting in favor of an adjusted actual. And I want to know why it's reasonable for me to do that. And I'd love to see the formula. Let's just say that you have some formula that you use to partially forecast these numbers. I'd love to see what that formula is.
A formula for how we estimate
Yeah.
our forecasts.
Yeah, I would really like to see that.
Well, we have discussed in prior testimony and rate cases what our process is for forecasting. So we have
Okay.
put that in testimony, and in this case as well. So we do describe our methodology for how we develop our estimates.
Okay, well, that's very useful to me. That's what I would like to see. Thank you. Thank you, Mr. Chairman.
And that should already be in the record, at least as it relates to the FFTY. We have that information in the record.
Okay, thank you, Mr. Chairman.
Mr. McLean.
Thank you. Good morning. Ms. Francis, would you agree that once the company files their actuals, that the stakeholders in the commission will be able to calculate a historic test year?
If we have enough time,
Right, but in theory.
yes.
Okay.
Well. There were still, with what I've seen that the companies filed, and again, this would probably be in testimony, we have seen, and I've outlined it in the motion in some small print footnotes, but that there are discrepancies between what we've seen with certain witnesses and the minimum filing requirement. So we've seen time periods where we have 3 different sets of numbers for supposedly the same thing. So theoretically, when you have updates to actuals and you have all of that information in the record, assuming you can look at it and make a determination. But there is also that problem if you want to take a look and compare what they're filing by FERC account. That information has not yet been provided. That's also in the motion. So whether you want to look at that or not, we think it's important to look at that to be able to verify the, quote, actual data that they filed. But it is not filed. We've been through witness
Okay,
Nelson's
okay,
testimony and
I
Alan's
got it.
testimony.
Okay. In terms of the voluntary DRs, you talked to them, that you classified them as patches or supplements, but they're not officially filed and they haven't been attached to anyone's testimony, correct?
They're filed, no, they are not attached to anyone's testimony. At this moment, they were uploaded to what Pepco uses, SharePoint. That's their external filing job.
Right, so until those things are actually presented to us, they're not part of the record, they're not supplementing anything at this point, correct?
You know, this is an issue that came up in D.C. They're part of something. I can't say it's part of the evidentiary record because they haven't been introduced yet.
Sure, and typically the companies don't introduce their own DRs, the parties do.
Don't say that.
Well,
That's,
typically.
no, we've seen instances where the companies have tried to do that, yes.
But that's not typical.
It's not a practice that is normally allowed in Maryland.
Okay,
However,
so it's not,
they
so
do
you
it.
agree with me?
Well, partially.
Okay.
It's something the company does.
We're just
They
pulling-
try to do it.
Okay,
They don't always get away
It's
with it.
not the norm,
but
though.
They
Okay.
try to do it.
okay. So there's no prejudice here.
The prejudice, well, that I disagree with respectfully. How the prejudice that I see is we will have approximately 18 days once we get the actual data, and we don't know when we're getting the actual data for the class cost of service studies or the jurisdictional cost of service studies that witness Schaefer said he will update.
Are we talking about the voluntary DRs or something else?
Oh, no, I thought we were talking about actuals.
No,
update to actuals.
no.
Okay.
I was just talking about the voluntary DRs.
Well, I don't know what the company plans on doing with them. I don't know. There was nothing that council suggested that could not have been filed with the testimony,
Okay.
whether attached to their policy witness testimony or some other witness's testimony. There was nothing there that could not have been filed
Okay.
before.
Okay, all right. Mr. San Martino, you made a reference to the historic test year, the 9 and 3, not being anything like you've seen before. And I'm assuming that you're referencing some of the adjustments are out in future years, correct?
Yeah, that's correct, Your Honor. I think, I have, I acknowledge that prior historic test year cases that have been filed, there's been a combination of projections and actuals. But I've never seen a series of rate-making adjustments that extend that adjust plant and service based on what the company anticipates to be the case in 2027.
Sure. So, but, leaving those aside, would you agree that once the company files their actuals, parties and the commission should, in theory, have enough information to calculate a historic test year, sir?
In theory, I agree. I think, though, that there's a problem with the combination of this, the completion of the record for a historic test year, and then parties also having to consider functionally a brand new approach to rate making in Maryland that the company proposes as part of their future test, the fully forecasted test year proposal.
Okay, thank you, sir. And finally, Ms. Curry, you said the update to actuals was typically around 2 months.
See, 2 to 3 months.
2 to 3.
In my research, 5 of the 6 cases, it was 2 to 3 months.
Okay. All right, thank you.
Okay, so we're not going to rule on the motion today, since at least 2 of the parties want to file information. So OPC said they were going to file on Friday, correct?
That's correct, Your Honor.
So I expect staff will file the same day. And I guess what I'm looking, I don't want to tell staff how to write their motion, but I guess I would be looking for some insight as to this dispute about what our authority is Okay, the extent of our authority, whether we can actually grant the motion as proposed by AOBA or limited to the actions that Pepco said we can do.
We'll do that. Thank you, Chair.
Okay,
And
Your Honor. Oh,
And I had actually asked Ms. Francis to provide information. Can she submit that on Friday as well?
okay.
Your Honor, I just want to say something. My consultant is listening. He has done some research while this proceeding has been going on, and I have not verified it because I have not looked at the order. This is coming from my consultant, and yes, I can file something on Friday. But there was no forecasting in case number 9286, and there was no forecasting in case number 9217. And I will check those as soon as I can get to my computer.
Okay, fair enough.
Your Honor, as we mentioned in our opposition to the AOBA motion, we asked for to reserve our rights to respond to
Sure.
OPC and now staff's comments. We'd like to reassert that right. And just wanted to quickly respond to AOBA's last comment. Just because there was one case that if there was something fully historical does not mean that a partially forecasted test year is prohibited. So I just wanted to make that distinction.
That's fine. Okay, so, all right, so I actually want to move on to a discussion about the proposed schedule, even though this might all become moot if we make a different decision. And it strikes me that the sticking point is this update to actuals. So the company proposed December 24, and I've heard, at least from OPC, November 27,
26, Your Honor.
25th, okay.
26, but I think we can, December 1st is probably the more reasonable proposal.
Which I guess, that was the date I got from AOBA, correct? December 1.
Correct.
What about staff? Did they get it?
Thank you. So during our discussions, we didn't challenge it, but we're not crazy about it. But we did not challenge it.
You're not crazy about what?
December 24th.
Well, let me put it this way, speak now or give your,
We could live with it. And again, during our negotiations, we did not challenge
all right,
it.
okay.
Yeah.
All right, so I guess one party can live with December 24th, but at least two don't want to. And I take it that December 1 might be a little difficult for the company to meet. So I guess what I want to hear from the company is what date would work between December 1 and December 24, as opposed to me just picking one. So
The reason we selected December 24th is we know what type of analysis we have to do. And so we chose that date based on what our expectations of our workload is. So I would stick with December 24th. We are, I do not see the reason to squeeze the company on this point. We have a 10-month procedural schedule. The other instances that I mentioned where we had an update to actuals in a 2 to 3 month period was under a 7-month procedural schedule, so 3 months shorter. I do not see a reason to squeeze.
well, let me put it to you. It does strike me, though, that December 24 is kind of an inoperative date for the other parties. I mean, I don't think that OPC, AOBA, and staff is necessarily seeing the actuals as what they want to see under the Christmas tree. So I think the company does need to be flexible on that particular date, because at least in my mind, that date doesn't work. Now, I am cognizant of the work that you have to do to make that happen, but what I'm saying is, from my viewpoint, 24 is not going to work. I'm giving you the opportunity to offer us a date where you think you can do it, or we're going to pick a date.
So what I'd like to do, because I understanding the work we have to do, if we could take a break so I could at least talk to the people who actually have to do the work, because I don't want to arbitrarily pick a date for you right now
Sure.
and end up, because at the end of the day, we want data that is accurate. The more you rush us, the more likelihood
and I
that we'll have
understand
to
that we-
file an
again-
errata. And we don't want,
Yeah.
I think there are worse off consequences if we are kind of rushed into doing this.
Okay, so I'm actually willing to do that. Why don't you tell me, how much time do you want? I mean,
Let's say 10 minutes.
all right, okay. So we're going to be, actually, we'll come back at quarter of. So let's. Okay, so back on the record.
We are willing to offer December 18th
Okay.
for update to actuals.
Anybody want to make any comments on that?
That doesn't work, Your Honor.
About what?
That does not work.
That doesn't work for you. Okay.
We're willing to consider it if the company also agrees to an expedited time frame for DR responses related to the update to actuals.
And, Your Honor, may I just add one thing? At this point, I don't know what Ms. Curry means when she says updates to actuals. Are we getting just numbers in some kind of a schedule? Are we getting an explanation? Are we getting testimony? I don't know what we're getting when,
Well, it strikes me though that I assume they're going to update as they've had in past cases. So I don't
But I don't know.
understand what the mystery is. So.
no, I don't know. Is they putting testimony to explain it? Are they just going to do a red line version with the numbers? Are they just going to change the numbers? I guess this dovetails on what Commissioner Barbe was asking about, what
So-
they are going to file when they file it.
Your Honor, I think some of the struggle I think we're all having, it's been a while since we've had to litigate traditional rate cases, and so we had to kind of go back and look at the history. What we anticipate doing is filing very, very slimmed down testimony and updated schedules.
Okay. So
And what about the request of OPC to expedite responses to DR requests?
We want to hold on 10 days, unless there is some precedent where we've accelerated it before in the past. It's hard to say to expedite it, not knowing what questions they're going to ask. But if that has not been something we've done in the past, we're not inclined to agree.
all right.
to it.
Before we get too far down that route, let me just stick with the dates at this point. So. All right, so at this point, if we adopt the December 18 date for the update to actuals, do we need to change anything else in the proposed schedule that Pepco filed?
Your Honor, I think for OPC, we could use a couple more days at least for the preparation of our direct testimony. So we'd propose instead of Wednesday, January 28th, either I think Friday, January 30th, or the Monday thereafter.
All right, wait a minute.
That's supposed to change the
That's assuming that the company is willing to provide an expedited time frame for
And then-
DRs related to the update to actuals.
So you're saying either Friday, January 30th, or Monday, February 2nd. So
Is that going to affect the rebuttal and
It-
surrebuttal dates as well?
We want to retain our time period for rebuttal testimony at 40 days. What OPC is proposing would cut into those 40 days for rebuttal testimony.
Well, so, and this kind of puts us behind the eight ball, but, we can cut into the end of the schedule. So to the extent that we sort of extend dates at the front end, we can maybe take it from the back end, although I got to be careful as to how much I cut into that. So, so if I give them January 30, then your testimony would be March 11. If I push that 2 days, then I add 2 days on yours.
Just looking at the date just to make sure things
Yeah.
don't fall on weekends.
Oh, that's well. Actually, according to your schedule says Monday, March
Okay.
9 if we move it to March 11, that should be Wednesday, correct?
Yes.
Okay.
Yes. And that preserves the 40 days of rebuttal.
That's,
Yes.
I mean, yeah, I would
We
think
could
it
agree
would,
to
yeah.
that. We could agree to that.
All right. So, do I need to do something with sewer rebuttal?
Can I see this?
We would need the 2 more days,
Okay. So we move
to April
that
16.
to April 16. Now, does that tighten the evidentiary hearing problem, or are we still okay with that?
Let me just double check the calendar. The evidentiary hearing
Right now is,
is on a Thursday.
right,
That means it wouldn't be able to start until that next Monday.
Right, and then just do it for the week. I mean, you were gonna have Thursday through Wednesday of the following week and Thursday, Friday, so just have it just Monday through Friday.
yeah, we could do that, so. So it would start on April 27th, so.
I have it, if we push it out 2 days, it's starting on May 30th. Wait, let me just
Yeah.
double check my calendar
Yeah,
here.
wait a minute. Yeah, according to the schedule I'm looking
Oh,
at,
the
the evidence.
27th, my apologies,
Yeah.
The 27th. So the
So-
27th through May 1st.
Okay.
I'm sorry, what days?
So the evidentiary hearings would start Monday, May 27th, and run through
April 27th.
April 27th, yeah. So, yeah, Monday, April 27th, run through May 1st. And if we need more time, we'll figure it out when we get there, so. Hmm? Well, as soon as we get done with the dates, I'll turn it over. And do we need to move the briefs, or?
Oh, Chair, we need the 2 spare days. We'd recommend you, so 4/27 to 5/1 for the 5 days for the evidentiary hearing, and then designate 2 spare days just in case, which would, I believe, would be 5/4 and 5/5. 5/1.
Yeah, that's a Monday and a Tuesday, yeah.
Right, and we don't want to cramp your style with your reviewing, but
Right, it'll just take 2 days, right?
Yeah. Well, I think that we can live with that, so we can make it work, so. But I guess the question now is, do I need to move the dates of the briefs?
5/5.
So briefs
Well, we could do that, yeah, I guess.
would be due June 2nd if we if we bumped it out by 2 days. And reply briefs due June 17th. And then I have 54 days to hearing. This is me looking at my calendar here, and other parties can let me know if those dates don't align.
Yeah, 54 days from June 17th to August 10th.
Yeah.
Yeah, I see that.
All right, I think we can live with that, so.
Ryan, could you repeat all the dates for me?
What's that?
Could you just repeat all the dates?
Okay, so the update to actuals is going to occur on December 18th, 2025. Staff OPC and intervenor direct testimony will be due on January 30th. Rebuttal testimony will be due March 11. The SIR rebuttal testimony will be due April 16th. The evidentiary hearings will start May 27th, or April 27th, and run through May 1st, with the option of 2 additional days of May 4 and 5, 2026. The briefs will be due June 2nd, 2026. Reply briefs June 17th, 2026. Then the orders April 10, 2026.
Excuse me, Chair Hoover, can staff be heard?
Sure.
We'd like to ask that you put in a date for the filing of the comparison chart that staff has to file. And we had talked about April 21 before. We didn't have an agreement. We just sent some messages around. But you would need to have it before the start of the evidentiary hearings. If they're going to be April 27, that's a Monday. 26, 25, 24, 20. April 23rd, we would recommend.
All right, I can do that. So.
Thank you.
Okay. Now, so that we're done on the dates, correct? All right, Commissioner Barbe.
Thank you, Mr. Chairman. I just would like to remind all the parties that a request that we had made was that the testimony be structured in separate PDF files, testimony, rebuttal, surrebuttal, rather than aggregating it all into one gigantic, difficult-to-search PDF. So I just want to remind everyone that that's the formal request that the Public Service Commission made, and
Your Honor, so if we file the testimony of two witnesses, you want them filed separately?
Yeah, right.
yeah.
Yeah, okay, got it.
And Your Honor, we did do that for our
Right,
reapplication.
and we appreciate
Oh,
that.
and
Yeah,
yes,
yeah.
and forgive me for not acknowledging
You
that.
file them together, Ms. Francis, but just two different documents.
Right, yeah, yeah. So, what we're trying to avoid are
Same topic,
1,000-page
different
Yeah,
PDFs.
or you could make numerous files.
Okay. All right, so let me move now to discovery. And so OPC made a filing of proposed discovery guidelines. So let me start with OPC's discussion about why they want to do this, and then I'll let the company react, and if staff and AOBA have any thoughts. Well, actually, let me start with OPC, and then I'll ask staff and AOBA, and then I'll let the company respond to everybody. So.
Thank you, Your Honor. So, we think that having the rules of the road laid out and expectations set for conduct during discovery is helpful for an orderly proceeding. And the rules that we proposed are generally, they're consistent with what's standard customary practice before the commission, as well with a couple additional suggested provisions specifically with regards to the treatment of confidential materials and the framework for how discovery disputes to be resolved, which from our perspective would improve transparency in this proceeding, as well as encourage parties to resolve discovery disputes without having to take them to the commission. So I'm happy to walk through the rules that we proposed, but I'm also happy to hear from the other parties and answer any questions that you may have.
Well, actually, does anybody here? All right, I don't think we need you to do the first part. So, AOBA, do you have any comments on?
No, I see them all as reasonable, and the commission should adopt them, especially the one having to do with confidential testimony.
Okay.
There's nothing else unusual in here. We support them.
Okay, staff, any thoughts one way or the other?
I think we were fine with them. I'd just like to verify with OPC, these are the rules you filed yesterday.
That's correct.
Okay. Yeah, we're fine with them. Thanks.
Okay, so Pepco, why don't you go ahead and?
Yes, there were two that we disagreed with. The first one is that parties that file testimony must serve.
Wait, actually, why don't you point me to, because he has it enumerated on their filing. So if you're talking about a specific enumerated item, just say that.
This is item number 2.
Okay.
filing the live Excel spreadsheets, or not filing them, providing them to the party. What we do is we upload it to a shared application within 2 business days of the filing of the testimony. We have proposed 5 business days, and that's just to give us the flexibility to format the Excel spreadsheets. I know it might sound easy to do when we make a filing and we PDF it, that we have the Excel spreadsheets ready to go. That's not always true. Just as to give one example, there are some tables that we attach to testimonies that are not already in Excel format. As an example, there is some forecasting software that we use, and the output of that will PDF it, but it is not in an Excel format, and we actually reformat it into Excel. And that's just to give you an example of why it's just not this quick process. And so we wanted the flexibility to take that additional time if we have some of those more complex work papers that we have to format. OPC is asking for 2 business days. We're asking for 5, again, just to give us those additional days if we do need it for those types of situations. And we're talking about like hundreds of spreadsheets sometimes, just as a whole. But we might run into some issues like the one I described, where it might be difficult to do that in 2 business days. So that's why we had asked for something in excess of that.
If I may respond, Your Honor. I understand that it takes time to clean up work papers and prepare them for service to all the parties. But that's why our 2 business day suggestion attempts to address that time. But these deadlines are known well in advance, so to the extent there's complex processes that the company has to do, I don't understand how the company can plan accordingly based on a 2 business day time frame for providing parties with the work papers.
And I'm sorry, Chair Hoover, may I be heard?
Sure.
And actually, I should have looked at this a little more carefully this morning. We've always wanted the Excel files that are whatever was PDF'd and filed in the testimony, and any of the commissioners can look in rate cases at the same time. We want them within, whenever you upload your PDF, you circulate by email to all the parties the Excel files. So we wouldn't want 2 days. I mean, I guess we could go with a day. 5 days is, I've never seen that in 2.5 years in any rate case. They're going to PDF what is in the Excel document. But I'm sorry, respectfully to Council, OPC, we would want at least the next day at the latest.
Again, just given the volume of what it is that we have to do, greater flexibility is better than little flexibility. Getting the files, obtaining them, formatting them, that really does take time. We could be willing to go to either or do 72 hours. I mean, we can try to the greatest extent that we can, or 72 hours, 3 business days. We can try to the greatest extent that we can to get those out, in the couple of days after the filing. It's just, sometimes we encounter issues where we may need that additional time, and so that's the reason why we wanted some additional flexibility.
Sure.
So, Ms. Curry, it's not that that someone's going to be asking you for information and then you have to go out and put it together. This is going to support your testimony. So it's everything that you knew sort of going into the filing of the testimony. And the concern I have is we've already heard that there are these incredibly tight time frames for preparing direct and rebuttal and surrebuttal, and I'm not understanding why it's not filed at the very same time that the testimony is filed. So I'm not even understanding the 2-day thing. I mean, or the 1-day thing. I mean, if the testimony is based on spreadsheets, that should all be filed at the same time.
It's not something we file. It's something we do upload to the parties, and we upload to an application. But given the example that I mentioned, that's just to give you an example of why it's not as easy an exercise. Sometimes it is not
But,
in an
but you
Excel.
could build that into, you're preparing your testimony. At the same time, you should be preparing for what you need to upload. I think that actually should be, I think it should be uploaded at the very same time that the testimony is filed, and you can come to us if there's a problem, or seek, some, go to the parties and say, I'm having trouble uploading it. But, we just got finished with sort of going through the timetable for preparing all of this testimony, and since it's coming from you to the stakeholders, it's not having an impact on your ability to prepare your testimony. It's directly impacting their ability to prepare their testimony. Mr. Chairman, I don't understand why it's not done at the same time. I think OPC's being a little too generous. I think it should be at the same, and unless, and if you're having problems, then you can talk to the parties about having problems getting that information to them. But this shouldn't be an issue. This is how you're supporting the testimony, and they have to wait 5 days before they can even see the backup information. That makes no sense to me.
Mr. Barbe?
So I always assumed, like most companies, Pepco lives on Excel spreadsheets, and I would presume that your analysts prepare all of the information and then you give it to, what are you doing with it at that point?
After when we file testimony, we PDF everything and we file it with the commission, and then we upload the live spreadsheets to an application that we use to serve the other parties.
Okay, well then that means you've got the spreadsheets already, do you not?
With the exception of what I mentioned about sometimes we do have to create documents, we do have to do some labeling of files. So there are some administrative tasks that we have to do. We're of course focused on filing, getting it filed and PDFing it, updating it, but to make it ready, we have to look to see if there are links in the document. So there is some level of analysis that we do before we make it available to the other parties, that we're not, we don't do that in parallel. We're trying to get the case out the door. We're trying to get it filed. So there is some level of analysis that we do.
Well, no, I get that, but I mean, what appears to me to be happening is your analysts and accountants produce produce an Excel spreadsheet, and then that Excel spreadsheet is put through an application and then sent out to everybody, but you still have the original PDF, the original Excel spreadsheet that you could then email to everybody also, don't you?
Not always. The example that I gave is sometimes we don't have outputs that are in Excel that we have to create later on. As I mentioned, sometimes we have output from one of our software that is not in an Excel format. We create that as an Excel file and submit it to the parties. So, looking at those types of things that we have to manage, we wanted some additional time. A day really is hard. I don't think any of the utilities do things in a day or turn
Yeah,
those
but
around
I've
in a
never
day.
heard of a company that doesn't do all of its analysis on Excel. I've just never heard of that.
It happens. It does. So we could agree to the 48 business, or I'm sorry, the 2 business days that OPC has proposed.
All right, well, so, all right, we're going to go with the 2 days. And if there is an issue that comes up, just contact the parties and I guess the commission if it's too big a deal, if you can't do that, so.
The other item to which we disagree is the stating a basis for discovery responses being confidential. This is item number 5. So when we file or when we submit a discovery request response, from time to time, we're going to designate certain ones as confidential. And what this asks is that the company provide a basis for designating any of those discovery responses as confidential. The reason why we push back on that is we have a protective agreement that we ask the parties to sign when we share confidential information. In that protective agreement, there are what that obligates us to do is, if we reasonably believe that there is a legally recognized basis for making it confidential, that is our standard. If we believe that there is a confidential basis for it, a legally supported confidential basis, that's what we follow. That's what our protective agreement requires us to do. So we already have a requirement embedded in the protective agreement of what we designate as confidential. It has to be kind of legally supported. If the parties disagree, the protective agreement also has a process for that as well. It says that it could be treated as a discovery dispute and resolved by the PSC. So the reason why we're pushing back on making this a discovery rule is that we already have a process, a requirement one, that when we designate something as legally confidential, we have determined that it is legally supported, and then Two, if a party disagrees with our confidentiality designation, they can simply challenge us on that. I don't know if this is something the parties have seen before in the past, but if they do disagree with something being confidential, they absolutely can come to us.
So let me ask OPC, I guess, why is the reason for making something confidential important to you?
Your Honor, in our experience, when we get confidential materials, all it says on it is confidential. It doesn't say, I think, if there's a critical energy infrastructure and information designation, then we know what the basis for some of the reported confidential information being set aside and redacted. But generally, when we don't know if is it proprietary information to the company or a third party. Is it financially sensitive information? We don't understand. We understand the company believes it's confidential,
right,
but we don't understand the logic and the basis.
I guess the question I have, though, is why does that matter?
It matters because if we think that if we understand what the basis for the designation is, then that helps us determine whether that basis is reasonable. And if we don't think it's reasonable, we have a right to challenge it. So I think the idea here is to streamline the process for addressing issues with over designations of confidential information.
Well, I understand that, but if you've signed the confidentiality agreement, you get to see it.
We get to see it, but our as the consumer advocate, our preference is for as much information that we see to be made publicly available.
Well, I understand that too, but.
And Your Honor, this provision is not intended to supersede what's in what would be in the protective agreement. This provision is mainly just to establish a standard for asserting information is confidential, then also I think the protective agreement that Ms. Curry refers to also has language about. If only a portion of the material includes confidential or proprietary information, the company should make reasonable efforts to designate only such portion as confidential or proprietary. And in our experience, we've had issues with entire documents being labeled as confidential when only specific information in it actually is.
Right, I understand that, but I guess I'm not sure how that problem is solved by forcing the company to tell you why something is confidential.
Well, and Mr. Chairman, I'm concerned that you've got then two competing documents, and you're going to be signing. Well, you're signing one, and you're asking us to approve the other, and I think it just creates the potential for some real problems. I think if you're signing the confidentiality agreement, you should address those issues within that agreement. But if you're signing that agreement and then we've got this, and then you've got two competing agreements, and if there's a problem, which agreement do you go to? How do they play together? I think you're just creating the potential for some mischief if you don't sort of focus on one have it be in one place. And if you're already signing a confidentiality agreement and you're concerned about only portions of the document being confidential, that could be addressed, I'm assuming, in the confidentiality agreement you're signing with the utility.
Sure.
May I be heard about this? So staff and OPC are not subject to the NDA. By statute, we don't have to sign any disclosure. We both OPC and staff can see whatever's confidential automatically. And the platform that Ms. Curry's been talking about, it has a separate channel, confidential, that we're both allowed to see. And that's a matter of statute. Number two, as Council has said, we've had times, respectfully to Pepco, where we've had to go back and forth. Please explain to us why you put a blanket designation on Blazunas' testimony in 9702, all confidential. So it took us. It would be a time saver to have.
Well, I understand that, but I guess my concern is this: I don't want to set up a process where we're going to be spending lots and lots of time. Pepco, make something confidential and give you a reason why they did it, and you don't seem to like it, and then you're in front of us and so I don't want to be in a position where we're deciding the validity of why something was made confidential. Now, I think in addressing staff's concern, it seems to me if they're being overly broad as to what they are claiming is confidential, that's a different issue, and I think that can be brought to us and we can decide that, but I still don't see what we gain by forcing the company to put a label on their confidential document as to why it's confidential. I just don't see where that gets us anywhere. So again, I'm willing to sort of address issues of confidentiality being too broad, and if there's problems with the agreement that's signed and limits on that, those are kind of different issues than requiring the company to tell you why something's confidential.
Understood, Your Honor. Our concern is mainly to the extent Pepco reasonably believes that something's confidential, we should understand where that belief comes from. And that's mainly what the first sentence in provision number 5 asks for. The second sentence is mainly, it actually incorporates this Commission's ruling in Order 90915 with respect to the accounting memorandum that BGE filed as confidential in case 9692.
So let me ask a question for Pepco. If on number 5, if we strike the first sentence, the second sentence is fine?
Redactions limited. I would say we do that. So just to give you an example, we turn over internal company presentations, and at the bottom it'll say confidential. But one thing that we do redact is if there is information to another related to another OPCO. Let's say there's a page that has ComEd information on it. We would redact that. We do that today. So we do when we see something where we do have the opportunity just to take out something that's not relevant. We do that today. So this language saying that redactions must be limited only to information that's designated to be confidential, I would say that we already do that. Although my only hesitation is Council just mentioned a specific case that I'm not exactly familiar with. He had mentioned this as tied to something that happened with BGE, so I'm not sure of the context of what OBC is mentioning and why this particular provision is in there, particularly if we're already currently doing it.
Your Honor, I'm happy to respond.
Sure.
The reference to the order with respect to the BGE memorandum, there's a paragraph in there limiting redactions and confidentiality designations to the specific information in a document that's actually confidential, and that comes from the Public Information Act. So it really stands for the proposition that is reflected in the protective agreement that Ms. Curry refers to, that redactions should be limited only to the specific information within a document that's confidential and not to the entire document as a whole. And I'll say for the Project Concurrence Committee slide decks that the company has provided, there are large redactions, which even though they're not specifically explained to us, we've been able to figure out over time that they do refer to the information of other utilities that are not a party to the proceeding before the commission. But for those entire slide decks, every single page says the material is confidential, and the whole slide deck is provided as confidential. But there are maybe specific bits of information in there, like in helpful explanation and context about a project, that we don't understand why that information is confidential. And it'd be helpful to the extent that, unless it's the company's position that every single word in that slide deck is confidential material, limiting redactions in those types of presentations, so it makes it easier for the parties to prepare cross-examination without risking going into confidential session, and to keep the public informed about what's implicated and involved in the rate application that Pepco is seeking.
Okay.
So those decks are, at the bottom, it does say confidential. So we've already determined them to be confidential. So even when we prepare the decks, it was confidential. So it's not something we're doing just for this rate case. It contains it contains internal information. It contains, let's say it contains information about rates or vendor costs. I mean, there could be various reasons why we would want to keep something proprietary if it relates specifically to, something involving our vendors. So there could be various reasons that we've designated them as confidential, but it's not by the function of the rate case. When the document was created, it says confidential on it. So I don't see the need to kind of assess or reevaluate it if we've already determined that this is information that is sensitive to the company, and we just frankly just do not want to take that risk, because I just think there's more risk than making something confidential that shouldn't be, particularly if the parties already have access to that information.
Okay. I know that as part of the scheduling order, we, have language dealing with discovery, so I think I'm going to be pushing this particular item off to that, and we'll issue instructions on it. So,
Ron, can I just address the labeling aspect of what we're talking about? And this is also a problem when it comes to the spreadsheets that Pepco provides in response to discovery requests. The whole filing, no matter how many sections of spreadsheet, it all says confidential either at the top or the bottom. When there is only certain specific things within those spreadsheets that is confidential. It's a problem when our witness is writing testimony and using that information, and he doesn't know what in his testimony is going to be confidential. And when we put on confidential testimony, we label the volume confidential, but we only put the redacted part. We're clear about the redacted part. With a spreadsheet, it's harder to do. So maybe what the company could provide is, when it's providing the data responses, please just state which portions or which sections of the data response is confidential. And that way they're not separating certain documents, but we know what we're using and how we can produce it in our testimony. It has gotten to be so much is filed in confidential form, it's difficult to determine as we're doing our testimony, what we can use where.
right. Okay. Well, like I
So
said,
we are in the best position to determine what's confidential. I understand the parties, they do want to bring as much out as public as possible, but really the company is in that best position to do that.
but I also understand that, because I've been doing this for a long, long time, and there is a tendency on the part of companies to want to make more stuff confidential than maybe is necessary. So anyway, we're going to address this in the order that we issue on the schedule. So
Your Honor, if I could also just bring up the question of an expedited time frame to discovery that's specific to the update to actuals.
okay,
Our OPC would propose that if the update to actuals is provided on December 18th, we have DR responses due within 5 business days. This is consistent with prior cases and prior procedural orders. In case 9472, which is a rate increase for Pepco, filed in 2018. There, after the update to actuals, the procedural schedule provided for 5 business days for service of the responses to DRs.
Yes, look at your calendar. Then that's December 25th.
That would be, yeah, that would be when so the update to, it's mainly in order to get ahead of discovery, so that we can have as much time so the parties can have as much time to analyze the update to actuals.
No, but if you're asking that your DRs be due on Christmas Day.
5 business days, Your Honor. So it would not be due on Christmas Day.
Well, I'm getting then. So you agreed
Would be.
to December 18th for the actuals, and then I've got 1, 2, 3, 4, December 25th.
yeah, that
For-
is 5 days. after
That's
the
5.
18th.
That's 5 business days.
That would be if we serve DRs to the company on the day that we get the update to actuals, which we would not be able to do.
I see. So what you're saying is, whatever day you serve the data request on
Yeah.
Pepco, you expect a response within 5 days.
Within 5 days. Okay.
For DRs, yes, that's correct, Your Honor.
Oh, okay.
For DRs specific,
The-
and this would
the-
be only limited to DRs related to the update to actuals filing.
All right.
So OPC and AOBA, one of the reasons they pushed back on the 24th is due to working over the holidays, but this proposal would require that the company do so. So 5 business days, that is tight, and it's over, since it is over the holidays, what we could offer is 7 business days.
Well, actually, I mean, but that presupposes that, you file on the 18th, having your people work that next week means that OPC would get the data request out the next day, which I don't think is possible.
We can do our best, but that'd be a heavy lift.
Well, I mean, since I don't know, using kind of worst case scenario, if they got that out the next day, that would put it in that following week, Christmas week, and we will have people out, and the parties will be out. The other parties, I imagine, will have people out as well.
Well, how much time do you normally have to respond to a DR?
10 business days.
10. So if they're willing to do 7, that's kind of
That work?
halfway?
We can accept 7.
Okay.
All right, so we'll do 7. Okay, anything else on the data request?
Nope, that is it.
Thank you. Do the commissioners, chair and commissioners, want to address the circulation of the Excel documents that go with the update to actuals? I know you had said it would be 2 days, but considering that there's, perhaps they could consider asking them to do it within 24 hours would be a request. The Excel spreadsheets
I
that support.
understand, but, I mean, it strikes me that we've got an agreement on 2 days, and I think that's,
Okay.
I mean, if the company can do it sooner, great.
Okay.
But they have to do it within 2 days. If they can do it sooner, that's great. So,
Thank you.
We wanted to do 2 business days, just in case
yeah,
it was
I
served
understand.
on a Friday.
Sure. And I'm saying that's fine, so. Okay, one last thing, just to make sure that we've cleaned up everything. We have a number of petitions to intervene, one by the Maryland Energy Administration, one by the Apartment and Office Building Association of Metropolitan Washington, D.C., one by the United States General Services Administration, one by Montgomery County, Maryland, Prince George's County, Maryland, and then finally the villages of Chevy Chase, the town of Washington Grove, the city of College Park, the city of Gaithersburg. So any objections to the petitions to intervene?
No objections.
All right, but that, they're granted, and